5 seconds to go. Start. Before adverting to the rival contentions with reference to application under section 156(3) CRPC within the parameters, we think it only appropriate to refer to the following decisions of this court in respect to the scope of exercise of power under section 482 CRPC. In Paramjit Batra versus State of Uttarakhand and others, this court held, while exercising its jurisdiction under section 482 of the Code of the High Court, has to be cautious. This power is to be used sparingly and only for the purpose of preventing abuse of the process of any court or otherwise to secure ends of justice. Whether a complaint discloses a criminal offence or not depends upon the nature of the facts alleged therein. Whether essential ingredients of criminal offence are present or not has to be judged by the High Court. A complaint disclosing civil transactions may also have a criminal texture, but the High Court must see whether a dispute which is essentially of a civil nature is given a cloak of criminal offence. In such a situation, if a civil remedy is available and is, in fact, adopted as has happened in this case, the High Court should not hesitate to quash the criminal proceedings to prevent abuse of process of the court. In Vesa Holdings Private Limited and another versus State of Kerala and others, it was held that it is true that a given set of facts may make out a civil wrong as also a criminal offence, and only because a civil remedy may be available to the complainant that itself cannot be a ground to quash a criminal proceeding. The real test is whether the allegations in the complaint disclose the criminal offence of cheating or not. In the present case, there is nothing to show that at the very inception there was any intention on behalf of the accused persons to cheat, which is a condition precedent for an offence under section 420 IPC. In our view, the complaint does not disclose any criminal offence at all. The criminal proceedings should not be encouraged when it is found to be mala fide or otherwise an abuse of the process of the court. The superior courts, while exercising this power, should also strive to serve the ends of justice. In our opinion, in view of these facts, allowing the police investigation to continue would amount to an abuse of the process of the court, and the High Court committed an error in refusing to exercise the power under section 482 of the Criminal Procedure Code to quash the proceedings. In Kapil Agarwal and others versus Sanjay Sharma and others, this court held that section 482 is designed to achieve the purpose of ensuring that criminal proceedings are not permitted to generate into weapons of harassment. In the decision in State of Haryana versus Bhajan Lal, a two-judge bench of this court considered the statutory provisions as also the earlier decisions and held as under, where the allegations made in the first information report or the complaint, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute any offence or make out a case against the accused. Whether the allegations in the first information report and other materials, if any, accompanying the FIR do not disclose a cognizable offence justifying an investigation by police officers under section 156(1) of the code except under an order of a magistrate within the purview of section 155(2) of the code, where the uncontroverted allegations made in the FIR or complaint and the evidence collected in support of the same do not disclose the commission of any offence and make out a case against the accused, where the allegations in the FIR do not constitute a cognizable offence but constitute only a non-cognizable offence No investigation is permitted by a police officer without an order of a magistrate as contemplated under section 155(2) of the code. Where the allegations made in the FIR or complaint are so absurd and inherently improbable, on the basis of which no prudent person can ever reach a just conclusion that there is sufficient ground for proceeding against the accused, where there is an express legal bar engrafted in any of the provisions of the code or the concerned act under which a criminal proceeding is instituted, to the institution and continuance of the proceedings, and or where there is a specific provision in the code or the concerned act providing efficacious redress for the grievance of the aggrieved party, where a criminal proceeding is manifestly attended with mala fide, and or where the proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused and with a view to spite him due to private and personal grudge. In Niharika Infrastructure Private Limited versus State of Maharashtra and others, a three-judge bench of this court laid down the following principles of law. From the aforesaid decisions of this court, right from the decision of the Privy Council in the case of Khawaja Nazir Ahmad Supra, the following principles of law emerge. Police has the statutory right and duty under the relevant provisions of the Code of Criminal Procedure contained in Chapter 14 of the Code to investigate into cognizable offences. Stop.